Boy, I sure love posting personal and work-related things on my Facebook account. This Freed guy really does not know how to deal with COVID at all. What the heck is his problem? I'm just gonna block this guy. All right, let's see what this guy has to say today. He can't block me. Just violating my rights.
The facts of the case are as follows. Prior to 2008, defendant and appellee James Freed created a personal Facebook account while he was still in college. Freed maintained this account throughout the years and under different employers. Freed's personal account grew until it reached a Facebook friend limit of 5,000 friends. Once the profile limit was reached, Freed converted his profile to a Facebook page, which has an unlimited number of followers. His page was public and anyone could follow it. In 2014, Freed was appointed city manager for Port Huron, Michigan. Once appointed, he updated his Facebook page to reflect his title. In the About section, he described himself as Daddy to Lucy, husband to Jesse, and city manager, chief administrative officer for the citizens of Port Huron, Michigan. Freed listed the city's website as his page's website, city's general email for city administrators and staff as his page's contact information, and the city hall address as his page's address. While acting as city manager, Freed would use the Facebook page to post information about both his life and city programs and policies. Some of the information on his page were pictures of his family, dog, and home improvement projects. He could also share information about communications from other city officials, soliciting feedback from the public, and mentioning actions Freed was taking as city manager, such as city audit reports, emergency directives, creating new offices, and so on. When describing these actions taken by Freed in the city, he would frequently use the words we and us. However, the page was still his own personal account. The city did not own or operate the page. The city provided no support for the page, and Freed never accessed his personal page on the city device. The issue that arises in this case was at the beginning of the COVID-19 pandemic. Freed posted about the pandemic daily, including media releases from health officials, Freed's own pandemic-related initiatives, and recommendations about citizens should interact safely around town. The post received a large amount of public engagement, many of which were positive and others that were negative, which Freed would occasionally delete. Kevin Lindke, a resident of Port Huron and plaintiff and appellant in this case, commented several times on Freed's Facebook page from multiple different accounts, criticizing how Freed had handled the pandemic. Under one of these posts made by Freed about the pandemic, Lindke commented that the response was abysmal and the city deserved better. According to Lindke, Freed initially engaged with some of the comments, but then Freed decided to delete Lindke's comments and block Lindke's Facebook accounts, so that he no longer could comment on his page. Once he was blocked and no longer able to engage Freed, Lindke sued Freed in federal court under 42 U.S.C. Section 1983. Section 1983 provides a cause of action when federal rights are violated by someone acting under color of any statute, ordinance, regulation, custom, or usage of any state. Shortly after the lawsuit was filed, Facebook deactivated Freed's account and throughout the litigation process kept reactivating and deactivating his account until Freed deleted his page himself. Lindke argued that Freed violated his First Amendment rights by deleting his comments and blocking him from the page. The district court granted Freed's motion for summary judgment, finding Freed's action did not constitute state action. Lindke appealed, and the Sixth Circuit affirmed the district court's decision, agreeing that Freed did not act under the color of state law when he deleted Lindke's comments and blocked his accounts. The test the Sixth Circuit used was the duty and authority test. Kevin Lindke filed a petition for writ of cert, which was granted by the Supreme Court. The issue now before the court is whether a public official's social media activity could constitute state action only if the official used the account to perform a governmental duty or under the authority of his or her office. Oral arguments were heard on October 31st, 2023, and we are awaiting the decision.
In Lindke versus Freed, the Sixth Circuit identified three potential tests set forth by the Supreme Court to determine whether the action in question was state or private action. The first test was the public function test. When employing the public function test, the court has found that a private entity may be considered a state actor when it exercises a function traditionally and exclusively reserved to the state. This was seen in Manhattan Community Access Corporation versus Halleck. Because the action is one which only the state traditionally engaged in, there is an appearance that the private entity is acting on behalf of the state, indicating that the state has at least permissively sanctioned such conduct. Where, however, the action is not one traditionally and exclusively reserved to the state, such as in Manhattan Community Access Corporation, courts are hesitant to find state action. Such action, at least superficially, differs from action which is traditionally and exclusively state action, in that the carrying out of the conduct does not appear to be sanctioned by the state because it does not appear to be under color of law. In this way, when a private entity takes action not traditionally and exclusively reserved to the state, it is not acting on behalf of the state, nor is the state sanctioning the action through carving out its traditionally held power and delegating it to a private party. The second test, identified by the Sixth Circuit, was the state compulsion test. This test was epitomized in the case of Addicks versus S.H. Kress and Company. The state compulsion test will identify an action as state action, even though taken by a private entity, when the private entity is acting as a result of a state-enforced custom which carries the force of law, compelling the conduct. Thus, private action that would be otherwise unconstitutional if carried out by the state is not protected in instances where the state has dictated the action of private individuals to further a scheme it could not constitutionally enact, though it desires. This scheme may be set forth in a statute or an unwritten custom. As seen in Addicks, even though Kress was not acting in accordance with statute when she refused to serve Miss Addicks, who was a white woman attempting to eat lunch with her African American students, Kress was carrying out the compelled custom of enforcing segregation in restaurants. This was demonstrated when Miss Addicks was arrested for vagrancy upon her exit from the restaurant. The Supreme Court has articulated the thought process behind the test in the case of Peterson versus City of Greenville. It stated, when the state has commanded a particular result, it has saved to itself the power to determine that result, and thereby, to a significant extent, has become involved in it. Because in Addicks, the state of Mississippi compelled the result of segregation in restaurants through enforcing customs which carried with it the force of law, the Supreme Court found that the state had become involved in the conduct. The third test identified by the Sixth Circuit in Lindke versus Freed was the nexus test. The nexus test seeks to address whether there exists a sufficiently close nexus between private party and the state such that the action is fairly attributable to the government. In a sense, the nexus test is a comprehensive amalgamation of the public function test and the state compulsion test, in that it simply analyzes whether the private entity's action is entwined with governmental policies or subject to the government's management or control. This was seen in Brentwood Academy versus Tennessee Secondary School. In this sense, a nexus between the action of private entities and the state may be established if either the private entity is engaging in a function traditionally and exclusively reserved to the state, or if the state is compelling the result of the actions through a means which carries the force of law. The Sixth Circuit notes that the three tests established by the Supreme Court to identify state action are tailored to identifying when a private party's actions may be attributable to a state. However, because there is no distinction as to when a public official's activities are personal or governmental, the Sixth Circuit sought to apply its own test, which recognizes the distinction between private parties and official actions. As such, the Sixth Circuit applied its state official test. This test is said to be akin to the nexus test established by the Supreme Court in that it takes into account factors considered by both the public function test and the state compulsion test. The state official test asks whether the official is performing an actual or apparent duty of his office, or if he could not have behaved as he did without the authority of his office. In this way, the test seeks to take into account whether the action is one traditionally and exclusively reserved to the states, is exercised only through the authority of office, or if the action is authorized or compelled by the state as a result of the office. During oral arguments before the Supreme Court, counsel set forth that the state official test reflects the Supreme Court's nexus test in that it seeks to ascertain whether the defendant's actions may be fairly treated as that of the state itself, although this test does so by examining whether the action was entwined with governmental policies or subject to the government's management or control. This test has alternatively been called the duty and authority test, as it takes into account both the duties of the governmental office and the authority that the position vests, explicitly or implicitly, in the individual. Ultimately, the Supreme Court must decide whether to adopt this test, an alteration of it, or apply an already existing test to a different set of facts. The ability of the existing and proposed tests were tested in oral arguments to determine whether they reflected the changes posed by social media.
The petitioner argues that the Supreme Court should use a state action test. This is a test that was devised by the petitioner, and they say that it is consistent with Supreme Court precedent under which a public official who purports to act in that capacity is a state actor. They say it also satisfies Section 1983 and the original understanding of what it means to act under the color of law. The test requires that a public official who creates a channel for communicating with constituents, which in this case would be the Facebook account that was used in part to reply to comments from constituents. It requires that when it involves in-office conduct and then the owner of the account blocks a user from that channel, that they must abide by the Constitution. This test focuses on how the public official is using and purporting to use that account, drawing a distinction between the account being purely private or a public account. The petitioner argues that the respondent's argument relying on the Sixth Circuit's duty and authority test would not be the appropriate test to use in this case, as they think it provides ready means for public officials to evade the Constitution. They also brought up a parade of horribles, saying that this test would allow the city manager to be free to block from his Facebook page any constituent who is a member of a disfavored race, religion, or political group, free from constitutional constraint. The petitioner in turn believes that their test avoids that result while still leaving ample room for public officials to communicate in their personal capacities. The core piece of the petitioner's argument is that this Facebook account has become a channel for public communication. What this means is that the account is no longer just a personal account, and that it has become this forum for constituents to ask questions and expect them to be answered. This is somewhere where they expect to be able to communicate with Freed about his job. The petitioner says that the pandemic caused a change in the ratio of personal posts to job-related posts because the services of his job and the way he was doing it migrated almost completely online. They say that once you've established a channel for communicating with constituents, there's the continued presence of personal posts does not take that characterization away from it, as the respondent in this case was still using his account in a personal sense. After being asked from several justices whether the fact that this account was not made in a public capacity originally, the petitioner said that the original intent for the account would be a factor, but this still wouldn't weigh against their case because there were significant changes when Freed took on the city manager job, such as his website on the page being the official city's website address. They also argue that since this is the only place where you can now interact with the city manager, that by being blocked by it, you lose access to a lot of information that this would not happen in regular life. This is a new way to infringe upon someone's rights to participate in government. The petitioner also specifies this by saying that a claim is present when an individual is blocked from a whole Facebook page because they lose access to the entire channel of communication. Whereas they have a deleted comment on a personal post, this would not constitute state action, as this could just be any other regular form of harassment if they're just insulting, I don't know, Freed's kids, as Gorsuch brought up. They say that this would not constitute state action. They also wanted to specify that a single work-related post on an otherwise entirely personal account would not instantly make it a channel for communication.
So in essence, The respondents argue that the court should adopt the Sixth Circuit's test. They argue that this test complies the best with the court's already established precedent in basically requiring that a government employee is acting with power granted to them by state law, or power that is only possible because they were clothed with the authority of state law. On the other hand, the petitioner's test will result in uncertainty and self-censorship for the country's government employees, as they won't know what they're allowed to share in their private or official capacity. The respondents state that the Supreme Court has historically found that government employees do not lose their rights by virtue of public employment, and the Supreme Court should continue on that path. They state that the Supreme Court should not be using a subjective test as the petitioner's test would be, but instead they must look factually and contextually. So for instance, if Mr. Freed decided to host a city council meeting via a Facebook live stream, this would be a different situation than what he was currently doing in this case. And that would likely be state action, as the public has the right to access that meeting. However, the most that Mr. Freed is doing is sharing action that has already occurred elsewhere on his Facebook account, as anybody might do with their friends or neighbors. Further, the respondents argue that Mr. Freed's Facebook account was a personal page, so when he was making his posts, he was speaking as a private individual, not as a government official, and thus there's no state action. Further, Mr. Freed, as the city manager, wasn't actually in a position where he was required to speak to the public, although the respondents were willing to say that that's often a responsibility of government officials. Mr. Freed was a city manager, so his position is unique in that he really has no authority to make or change policy. All that he's really doing is recommending what he thinks is best to the city council, and then they end up making the decisions. So for instance, Mr. Freed issued a water directive specifically to the water department, as opposed to issuing it in some sort of public statement to the constituents. Additionally, he is an appointed official, not an elected official. If Mr. Freed is merely reposting or resharing official action that he's already taken onto his Facebook page, there's no state action. It's further established in this oral argument that the clout of the city manager position does not transform action into state action. So it's no different just because Mr. Freed is in a position of public authority. He can still share the current events just as any random person could to their neighbor. Other factors to consider in whether the page is a personal private page versus a more public state action sort of situation would be if the government employees were helping to maintain the page, if government funds are used in maintaining the page, or if the page is owned by the government. This would not include the function of the page. Finally, Masha Hansford gave an additional argument in support of the respondent on behalf of the United States. Their argument, in essence, was that Mr. Freed's Facebook account is private property, and thus it's necessary to look to the duties of a city manager's role to determine if that makes him responsible for communicating with the public. Here, as mentioned in the previous slide, he's in charge of administrative tasks and not a specifically public-facing position. And even so, regardless of the subject matter, it's dangerous to assume that something occurring on private property is state action, absent a duty to communicate that information.
The court appeared to be favoring the respondent after looking at the oral arguments. They seem to take a big issue with the shift of a private page to the public usage, as the petitioner was trying to bring up. And they also did not seem impressed with the petitioner's custom test that they were trying to implement. They poked a lot of holes in it, and they were really making fun of it at times. There was a number of times that they were making jokes about whether somebody being blocked after insulting the government officials' children or their cat, or cat pictures that they like, whether blocking them would be a state action. and they just seem to not find the test very credible. Now, for the respondents, they still saw some issue in that they were trying to come to terms with whether a Facebook page would be private property, but they still seemed in favor of weighing that direction. None of the judges, though, were clear on what it is or what test they wanted to use. So it makes it very difficult to predict which one that they would try to implement. They all agreed that there should be a standard, but they just could not come to any sort of agreement on what factors were relevant to the assessment. This was leading us to think that a plurality opinion could result if the justices could not come into agreement, or alternatively, it seems most likely that they would come up with something similar to the Sixth Circuit's test, since that just seemed to be a little bit more convincing, yet they still weren't entirely happy with the idea of the Facebook page being private property, but we could at least predict that the respondent is probably going to win this case.